Ever stop to think about just how much personal information your employer actually has on you? I mean, contact details, bank info, maybe even health stuff.
Oh, absolutely. It's a huge digital trail. And how companies handle that data, it genuinely affects your career.
Right. It's not just some abstract thing online.
Exactly. So today, we're really diving deep into the federal data privacy laws that cover employee records. We'll look at things like the Privacy Act, FLSA, IIPA.
And state laws, too, like California's.
Yes, we'll touch on the CPR, CCPA, because it's really changing the game. Our mission here is to sort of unpack these rules.
Make sense of it all.
Yeah, and show you how they can impact your professional life. Plus, the pretty serious financial side for companies that get it wrong.
Okay, it sounds like a complex web. Where's the best place to start untangling it for understanding how our, career data is protected?
Well, a really foundational law is the Privacy Act of 1974. Now, you need to know this one specifically applies to federal government agencies.
Okay. So federal employees.
Right. It dictates how they handle employee PII, personally identifiable information, your name, social security number, all that basic stuff. Think of it as the government's own rulebook for its workers' sensitive info.
Gotcha. So if you're working for Uncle Sam, this is key. What does it actually do? What protections are there?
It gives you some really important rights, like the right to actually see your own records.
You can see what they have.
Yes. And you can request corrections if something's wrong. Plus, it puts strict limits on who they can share your information with. And get this, the enforcement isn't trivial.
Oh.
So far, we're talking 152 civil money penalty actions under this act. The total, nearly $145 million in settlements and penalties.
Wow. $145 million just from this one act. That's significant.
It really is. It shows these aren't just suggestions. There are real teeth behind them. Federal agencies can't just, collect and share data freely.
So there are checks and balances.
Definitely. The Privacy Act also makes agencies publish something called SORNs, Systems of Records Notices.
SORNs? Okay, what's that?
Think of it like a public list of their digital filing cabinets that hold your personal info. It says what's in there, why they collect it, how it's protected.
Transparency, basically.
Exactly. And they also have to do privacy impact assessments before collecting new kinds of data, sort of checking the risks first. If they don't do this, it can trigger investigations and those big penalties we mentioned. It's about building privacy in from the start.
That makes a lot of sense. Proactive assessment. Okay, so that's the federal government side. What about the rest of us? Private sector employees.
Right. For the private sector, a key one is the Fair Labor Standards Act, the FLSA. It has big implications for employee data, especially around record keeping.
FLSA. That's mostly about wages and hours, isn't it?
Primarily, yes. But to enforce that, it forces employers to keep very specific, accurate records for non-exempt employees. Things like hours worked, wages paid, some personnel details.
For how long?
Generally 3 years for most of that. Pay differential records, like under the Equal Pay Act, need to be kept for 2 years.
So even though it's about pay fairness, it creates a ton of personal data employers have to hold on to.
Precisely. Just think about all the personal and financial details tied up in those records for every single non-exempt worker. And the Department of Labor. They take FLSA compliance very, very seriously.
How seriously? Are there numbers on that?
Oh, yeah. Fiscal year 2024, they recovered $202 million in back wage.
200 million.
Yep. For over 151,000 workers. That averages out to about $333 per person who wasn't paid correctly. That's real money, a direct hit to people's wallets.
Definitely makes a difference. But I think the sources mention more penalties for employers, beyond just the back pay.
Yes, absolutely. And this is where the costs can really pile up for businesses. Last fiscal year, the DOL collected another $156 million for other FLSA violations.
Okay, like what?
Well, a big chunk, $130.7 million, was for overtime violations, another $20.9 million for minimum wage issues, and $4.4 million for child labor violations.
Serious stuff.
But specifically on the record-keeping side, if employers mess that up, they can face penalties around $2,050 per employee.
Per employee. Wow. Okay, that could add up incredibly fast for a company.
It really can. And it gets worse. If an employer willfully falsifies records, like deliberately lies about the data.
That sounds criminal.
It can be. We're talking potential criminal fines up to $10,000. And on a second conviction, even imprisonment. So for you as an employee, having accurate FLSA records isn't just about your paycheck today.
It's about proof later on.
Exactly. It's your legal record of work history, compensation, crucial for future jobs, loans, resolving disputes. It's fundamental to your economic security, really.
Okay, so general data handling in government wage and hour records. What about the really sensitive stuff, like our health information that employers might get through, say, insurance plans?
Ah, yes. That brings us squarely into HIPAA territory, the Health Insurance Portability and Accountability Act.
Right, IPA. Everyone's heard of that one.
Its privacy and security rules are designed specifically to protect your PHI, protected health information. And yes, your employer often falls under this, especially when they administer health plans.
And I bet the enforcement here is picking up too, given how sensitive health data is.
You bet. We're seeing a clear upward trend. HHS's Office for Civil Rights, OCR, they handle HIPAA enforcement. Remember that $144.9 million penalty total we mentioned for the Privacy Act?
Yeah.
Well, OCR has also resolved 152 HIPAA cases with civil money penalties totaling. Wait for it, $144.9 million. Same figure, interestingly enough, across both acts for their major CMP cases.
Wow. Okay, so they are definitely active.
Yeah.
What kind of penalties are we talking per violation for IPA in 2024?
The range is, frankly, huge. It can go from $141 for a minor violation up to potentially $2.13 million for a really severe one.
$2 million for one violation.
Potentially, yes. And there are annual caps per type of violation that can also reach $2.13 million. It really depends on things like negligence, was it willful, that sort of thing.
That massive range definitely signals how seriously they view this. Is enforcement actually getting tougher, more frequent?
Seems so.
Right.
In 2023 alone, OCR wrapped up 13 enforcement actions. The total penalties, $4.18 million.
Okay.
That's nearly double the penalty amount from 2022. So yeah, the trend points towards increased scrutiny. It just highlights how vital it is for your personal health info to stay private at work and the massive risk for employers who drop the ball.
Okay, so federal laws set a floor. But you mentioned California earlier, kind of leading the charge.
California really is a trendsetter here. Their law, the CPRA, California Privacy Rights Act, it built on the older CCPA. And in 2023, it did something huge. It got rid of the exemption for employee data, meaning your HR records in California now basically have the same kind of rights as consumer data. It's a big shift in how California employers have to treat employee info.
So if you work in California or even apply for a job there, what new rights do you have now regarding your personal info?
You get several key ones. The right to know what personal info they're collecting and why. The right to ask them to delete it, in some cases.
You can ask them to delete your HR records?
Under certain conditions, yes. Also the right to correct inaccurate information. And crucially, the right to opt out of them sharing your personal information for certain purposes. It's about giving you more control.
That does sound like a major step up in employee power over their data. What does this mean for employers there? What hoops do they have to jump through?
Well, several big ones. They have to provide a specific privacy notice for HR individuals laying out their data practices.
Yeah.
And they have to respond to your requests, like to see or delete data within 45 calendar days.
45 days. Okay.
They can potentially get a 45-day extension, but that's the timeline. And the California Attorney General isn't waiting around.
They're checking up on this.
Oh, yeah. Back in July 2023, they sent out inquiry letters to a bunch of large employers, specifically asking about their CPRA compliance for employee data.
So they're actively policing it.
Definitely. It signals this growing momentum for stronger employee data rights at the state level. And you know, what happens in California often influences other states down the line.
Right. Okay, so we've got the laws, the fines for breaking them. But what about when things go really wrong, when data actually gets breached? That's a whole other layer of cost, isn't it?
Oh, absolutely. The financial fallout from a data breach involving employee records can be massive, often way bigger than the regulatory fines themselves. Get this. In 2024, the global average cost of any data breach hit a record $4.88 million.
Wow, nearly $5 million average globally.
Yep, and that's up 10% from the year before. It shows the financial risk is just climbing.
And I remember reading the U.S. cost is even higher.
Unfortunately, yes. The U.S. leads the world here. The average breach cost in the States is a staggering $9.8 million.
$9.8 million per breach.
Per breach, on average. And if you drill down into the cost per record that's stolen, globally, PII costs about $169 per record. But employee PII, it's even more valuable, apparently. Costs about $181 per record when breached.
So employee data is extra sensitive extra costly if lost.
Seems that way. It really drives home how valuable your personal data is to potentially malicious actors, and huge financial hit if your employer lets it get compromised.
And these breaches aren't small, are they? How many records typically involved?
The average breach size is now around 30,000 records. That number is also growing about 7% year over year.
30,000 records at $181 a pop for employee data.
Yeah.
You can see how that $9.8 million average happens fast.
Exactly. And compounding the problem, it takes a long time, on average, to even spot and contain a breach. We're talking about 280 days.
280 days. That's
Right.
like 9 months.
Over 9 months where the breach might be ongoing, data leaking out. It's a long time. There is a silver lining, though. Companies using security AI and automation, they save, on average, $2.22 million per breach.
So technology helps, but the core risk is huge. Okay, we've covered a ton of ground. Laws, fines, breach costs. Let's tie it all together. How does all this actually impact me, the individual employee, navigating my career?
Right, the so what question. Let's connect those dots. Think back to FLSA. If your employer's records about your hours or pay are wrong,
You lose money.
you could be losing earned income, yeah. And you might struggle to prove your work history later if there's a dispute or you need it for something else. It directly impacts your finances and career records.
Okay, that's clear. What about HIPAA?
A HIPAA breach exposing your sensitive health info, that could potentially harm your reputation. Or, even affect future job prospects if that private information gets misused somehow.
I'm thinking about California's CPRA, CPA. Those new rights give employees more leverage, which could also play into career stuff.
Absolutely. Those rights let you demand transparency, you can push back on inaccuracies, request deletions in some cases. It gives you a direct hand in how your employer manages your data narrative, essentially, throughout your time there.
And just generally, if a company is sloppy with data, it says something about them,
Right.
affecting job security.
Exactly. A company that suffers a huge breach due to carelessness, that can cause major reputational damage, financial instability, which, could absolutely impact your job security and growth opportunities there. It reflects on their overall management and stability.
So understanding all this isn't just legal trivia. It's about protecting our money, our health privacy, ensuring fair data practices, all things that really matter for our careers.
Precisely. Being aware of these laws, the potential consequences, it empowers you. It highlights why it's important to maybe consider working for places that clearly prioritize data privacy and security. It's part of being a responsible, stable employer nowadays.
Okay, let's wrap up this deep dive then. What's the absolute core message you want people to take away from all this?
The main thing is this. These data privacy laws about your employee records, they are not minor details. They matter. They have real, significant consequences, both for your employer and for you.
Big financial penalties.
Huge penalties for noncompliance, yes. And the costs linked to data breaches involving employee info are equally massive, millions on average. All this just underlines how critical it is to understand your rights and maybe, just maybe, to choose employers who take this stuff seriously.
Right, so here's something for you, our listener, to think about. Knowing what you know now about how these privacy laws can affect your career, what questions should you be asking your employer about how they handle your data? Maybe it's time to get a bit more proactive about your own data privacy at work.
Thank you, viewers, for watching. If you found this video helpful, don't forget to hit that like button and share it with your colleagues. And if you haven't already, make sure to subscribe to the channel by clicking that subscribe button below so you never miss out on valuable insights. I'm Brian Edmonds, signing off. See you in the next one.